Hello, hello, this is Patty Jo, and we are on, I don't know what day we're on, day like 9 or some, day 9. And it is time for Darrell, Terrible Darrell, the troll, to stomp through the testimony of the person who he's gotta hate almost as much as he hates Sue Opper. And he's gonna question him. Now I don't know if I'm gonna make excuse me, make it all the way through this one, because I've got to take Carly to the vet. Check to see what time that is, but the little drama queen's not going to like it. No, she's not sick or hurt. She's just going in for a regular checkup, heartworm test, and all kinds of stuff. So she's going to hate it. Act all dramatic. Okay, so let's go.
I appreciate everyone's patience as we were able to at least complete the direct examination. When we come back from lunch, Mr. Brooks, you can start your cross-examination. We'll take an hour and 15 minutes, so come back at 2 p.m., everyone. All rise for the...
Yes, do my morning skip, which I think is just my computer.
Lunch break now. It's 12:43. I appreciate everyone's patience as we were able to at least complete the direct examination. When we come back from lunch, Mr. Brooks, you can start your cross-examination. We'll take an hour and 15 minutes, so come back at 2 p.m., everyone. All rise for the jury, please.
Look at him rocking. What's he rocking for? Like some kind of psycho. It's how a child soothes themselves. He actually has some fear. Oh no. No, no, not something. Oh God, it's reminding me how gross I was when I was sick. Ugh. Ugh.
On the record in State versus Brooks, appearances are as they were before. Just want to make a quick record. It's not something we need to address right at this moment. I provided to the parties the pattern jury instruction 152 related to jury view, and then an instruction I drafted based on that. And I say based on that because this has to do with the view of the vehicle, because I view a view of a scene differently from a view of a vehicle, which is evidence. So again, we don't need to go over this now, but I at least wanted to give those to the parties so that when the appropriate time comes, we can discuss whether the court should say anything regarding the view of the vehicle, if that is in fact still the request of the state, and then if so, what that should be. So I've provided that to both the parties in written form. Go ahead.
Actually, I appreciate that, and I wanted to bring this up this afternoon so we can plan. Obviously, I don't know if the mics are on.
It should be. Yeah.
Okay. I'm soft-spoken, I'm sorry.
Said no one ever. That was all loud, sorry.
So, with the court's permission, we would like to schedule the jury view to occur at 12 noon tomorrow. Now, we may not be through testimony at that point with the state's case, but like we did with the interpreter, if we could get a commitment from the court to pause whatever we're doing around 11:45 or 12 noon tomorrow and lead the jury to the location for the jury view. There's obviously some planning that needs to take place by the sheriff's office. The tow truck needs to be arranged, and I believe the maintenance division needs to assist in some way as well. So what I'm learning is that it's best if we just pick a certain day and time and set it, and then, you know, again, with the judge's permission, kind of work around that in the courtroom. So that is our request, if the court is willing to accommodate that.
In regard to that request, I know I had internal discussions with the sheriff's department because they're in charge of security over the trial, and I don't frankly know how much we've talked about this previously, but it is in a secure location, or will be. I've made arrangements, or I've instructed the sheriff's department that because of the location that we will be in, it's not something that will be that anyone can just follow us to, but a contemporaneous recording will be made and then placed into the record so that the public is aware of what happened, but after. So I did want to add that to the record. In terms of the request, Mr. Brooks, this relates to the viewing of the vehicle that was recovered by the Waukesha Police Department. There were preliminary discussions when you were still represented by counsel.
Okay, so my understanding here, and correct me if I'm wrong, because we all know I'm no attorney, but this is to view the vehicle, being evidence of what he used to harm and to unalive the people in question. So I would have to assume that his attorneys did fight against this when these hearings were held, because it would be their due diligence to say, oh, let's not look at something that is completely devastating to our case. You know, so, and then of course I would assume that it would then be overruled because it's completely relevant to the crime in question, the crimes in question. So since they cannot bring the vehicle into the courtroom to show the jury, they're taking the jury someplace to show them the vehicle. Okay, and she's going to say how she's going to record this. Now let's see Darrell's temper tantrum.
And the request is being made that the viewing of this vehicle take place tomorrow. Your response, if any?
First of all, I accept for value in return for value this paperwork.
Meaningless.
I guess I'm still confused as to why there needs to be a jury view.
I can have the state put their request on the record again. I'm responding to their request. So go ahead, Attorney Opper.
Yes, Judge, and I believe the court has already approved this request. A motion was filed and ruled on by the court previously, but as Mr. Brooks has been charged in every count with acting while armed with a dangerous weapon, we believe it's relevant and appropriate for the jury to view what we're alleging to be the dangerous weapon in this case, that is the 2010 Ford Escape. It's essentially would be no different than bringing a firearm into the courtroom during a shooting case.
And I would just simply note the first degree intentional homicide and first degree recklessly endangering safety charges are what carry the enhancer for use of a dangerous weapon. Of course, the hit and run does not have that enhancer, nor do the bail jumping and batteries. But with that caveat.
Yes, thank you for that correction, Your Honor.
All right. Mr. Brooks?
I'm confused to that too. Why are there only certain charges that have an enhancer?
Well, the court's not going to answer that, sir. Those just happen to be the charges. The state is tasked with proving each one of those charges and any special verdict question that goes along with it. Beyond a reasonable doubt, they bear the burden of proof, as was spelled out in all of the preliminary jury instructions. So that's how I'll answer that. In terms of the jury view, I did grant the motion previously. It was unopposed.
Unopposed.
And I'm not hearing anything that
Because it's
would
ridiculous.
cause me to reconsider that. In terms of the time that's being requested, do you have any position on that?
So really, the only question
Do I have
is,
to be present?
the only question is, is the timing okay during the trial, which is meaningless to me.
For this?
I would like you to be, and yes, we're making arrangements for you to be there, sir.
Do I have to be present for it? And also, for the record, I don't consent to the name that's being referred to.
Who cares?
I'll use this opportunity, sir, to ask what name you prefer to be called, because we now have evidence in the record where you provided your name to, upon questioning. There was video from when you were taken into custody, and then, of course, Detective Carpenter has testified about that as well. Again, I try to refer to the parties by name because that is how I believe I demonstrate respect and decorum in this courtroom. And we've been given no other name, sir, by which to call you by.
So she finally did it. Here it is on day 9. So what do you want me to call you? Terrible Darrell, the ogre, troll, dumpster, goblin? What?
I must, at that point, go back to what's on the criminal complaint, which is the initial charging document.
She also pointed out that he did say, Brooks, my name is Darrell Brooks. He confirmed it during questioning. He signed his name, Darrell Brooks, on papers when they read him his Miranda rights. All those things. Darrell Brooks, you said it.
That is what was filed in order to initiate the case.
With all due respect, the record should be corrected. I didn't put anything on the record that was...
Yes, you did.
I said there's
said
evidence in the record.
Well, evidence, what
What
you referred that evidence to me.
So there's evidence in the record, but be that as it may, I'm just letting you know I'm going to keep referring to you sometimes as defendant, sometimes as sir, sometimes as Darrell Brooks, sometimes as Mr. Brooks. I understand you may still have an objection, but I've been given no other name from you by which to call you.
I follow, but there's still a lack of understanding. Are you referring to the name that was in all caps on all the filings?
Of course,
Because
not
every
gonna answer
filing that I
sir.
have,
I find the response to be kind of disingenuous, sir.
so there was
This is, I believe, a tactic by you to create some type of confusion, which I don't believe there is any, about who you are and what name I need to refer to you as.
I never said you had to refer to me by any specific name. That's not what I'm saying. I'm saying that every filing that has ever been filed was in capital letters. That's a fact. I have paperwork to prove that. I don't recognize that name, nor do I know any individual by that name. That's all I'm stating.
Well, let's assume for a second that it's not in all caps. Do you recognize that?
No, I do not.
Okay, well,
Because
we have
there
our
were-
answer then. We're going to keep going, sir. We're a little bit off topic. In terms of the request by the state, I'll give you one more opportunity to answer
Answer the
that. They've
question.
requested that whatever we're doing tomorrow morning, whether it be their case, whether it be if you are calling witnesses, that we pause about 11:45 in order for the jurors, the court, and the parties to be taken to that secure location for that jury view. Do you have any position as it relates to that?
Yeah, my position was when I answered, I said, do I have to be present?
I'm requiring you to be there, yes.
And what reason do I have to be present?
Unless you're willing to go through a colloquy with this court and intentionally waive your right to be there, because then I'm going to require you to be there.
And that's not explaining why I have to be there, though.
Because I'm requiring you to be there, sir.
And you just made that decision now?
All right. He's not answering the question that I asked him. We will pause
I'm
at
trying to get
approximately
understanding, that's all.
11:45 tomorrow morning for that jury view of the vehicle to take place as soon as we're able to walk over there. But I think given the logistics of everything, it is on campus, but it is in a secure location. That will take place approximately at noon. And as I indicated, the court will require the sheriff's department to make a contemporaneous video of that view, which will subsequently be made part of the record to capture that.
Don't I have rights, though, Your Honor?
All right, then with that,
Another question.
Go ahead.
Scheduling, Your Honor. Could you please indicate your intentions as to how late we will proceed this afternoon so we can line up witnesses?
sure, I'd like to try to, we had a little bit of a long day yesterday, so I try to balance that out for the jurors. So generally between 4:30 and 5 is when I would like to break, depending on where we're at. If we need to go a little earlier because of the witness, or if we need to go a tad later, that's fine as well.
Okay. And then the last item, Your Honor, is that, to my knowledge, we still have not received anything from Mr. Brooks as to the date and time when he would like his witnesses ordered to appear. I don't see anything was e-filed. So
No,
if he
another
is still
temper tantrum.
requesting the assistance of the state to secure the appearance of those witnesses, we will need that information, Your Honor. He does not have to give us the exact order, but if he could tell us, as you had suggested, either morning or afternoon, and what day of the week he wants these people here. We have served the subpoenas that he requested at his request in order to assist him. And these witnesses obviously have jobs and other commitments, so it's reasonable to be able to give them a time frame on when they need to be here.
With that, when do you expect to rest?
We're still hoping to rest by the close of business tomorrow, Your Honor, unless something unforeseen happens.
So we're talking about Thursday and Friday at this point.
Yes.
Which is what I suggested from the beginning yesterday.
But Mr. Brooks, we need to know which particular witnesses on which day and whether it's AM or PM. Don't need to give me the order. We'll have them come in groupings, but it's not reasonable that they all come on the same date.
I never
So-
said it was.
All right, so you need to provide that to the DA.
How am I supposed to provide that to the DA?
You can write that down, or you can put it orally on the record right now. I asked you to bring it with this morning, and I didn't cover that this morning, so you were put on notice of that. But I'll give you until,
I was put on notice of what?
let me ask Attorney Opper a question. Would tomorrow morning first thing be sufficient for the state to make those arrangements, given that you don't believe you will close your case until the end of the business day tomorrow?
I mean, I understand what the court's saying. I think that's reasonable, with the understanding that if somebody needed to give notice to an employer and it can't be accommodated, then that may affect things for Mr. Brooks. But I think 24 hours notice is generally reasonable, and we will do our best. We can assure the court we will do our best to get them here, but I don't know if we'll be able to exactly accommodate the timing that he may or may not want.
He really thinks that everybody should be at his beck and call. He really, really thinks that. This whole three-ring circus, Barnum and Bailey would be jealous of. He's exhausting.
All right, so Mr. Brooks,
Objection to that, because
Objection.
when the subpoenas were served to them, I'm assuming that they would have let any employers or anything know that they were expected to testify in a trial. I don't
They still
understand
have
why it will become a problem at the last second.
Well, if you recall, sir, at the end, near the end of last week, I don't recall exactly what day we were on, but we knew we weren't going to finish with the state's case at some point, and we had a discussion on the record. If there was any objection by you, if the state told those witnesses they didn't need to appear on Friday, so it obviously had to have been before Friday, that they didn't need to appear and that they would work with those witnesses to provide them with a more definitive time. So now is the time when we need to provide them with more definitiveness. So by the start of court tomorrow, you need to bring with you, either in writing or be prepared to put it on the record orally, which witnesses you want. We'll start with Thursday morning, then Thursday afternoon, Friday morning, and Friday afternoon. I don't need to know the order, but I need to know the day of the week, right? So Thursday or Friday. I would just note the dates for those. Thursday is the 20th, Friday's the 21st, and then which witnesses. Only you know how much you want to question them, so you should be able to gauge if we can get 2 in each morning or afternoon, 3, 4, whatever. Use your best judgment on that.
Yeah, I don't know how I'm going to come up with exacts on that.
I presume you're going to prepare some questions and you might be able to kind of gauge how quickly that will go or not. If not, we'll do our best, but you've got to provide some definitiveness. It's not reasonable to just have these witnesses all come on one day.
I'm informed of what you're saying. I just feel like that same courtesy wasn't afforded to me by the prosecution. They didn't have to tell me exactly what witnesses was being called on what day and all this and that. Why is it not
I am requiring it, sir, because they are assisting you, because they graciously agreed to do that because you are representing yourself. If you want them to be out of the loop on that, then I can just put it on your responsibility and your shoulders. But that is up to you.
What do you mean by putting it on my shoulders?
What do you mean?
can contact them.
What do you mean? I have to be responsible for it, Darrell. You horrible, hypocritical monster. Oh my God. What do you mean me? Ugh.
How am I supposed to do that?
You have access to a phone in the jail.
So I'm supposed to call everybody that I subpoenaed, not knowing their information?
Yeah, it's right there in the box.
That is one way to do it, sir. Their information is in the police reports.
That is highly unreasonable. When one person that's on my witness list, I'm not even permitted to have contact
That
with.
would be a good exception to that. So that's very astute of you to point that out, sir. That would be one exception. But other than that, in any event, sir, we're kind of a bit off track. We're going to get back on track, and you need to provide the information that's provided, that I've outlined here today.
I don't think that's fair, Your Honor.
Your objection is noted, but it's my ruling.
The state didn't have to do that, but I...
trying to say one horrible thing we used to do in the medic unit. Okay, because one person would be taking like the notes and the report and doing the stuff on the computer, while the other person would generally be doing the vital signs and asking the questions, and while the other person's kind of scribing it down. The person doing the computer and everything was kind of in charge. And this was for your basic calls. This wasn't for like the dumpster fires, the train wreck calls. This is for, people who just needed a ride or didn't know what to do, or they don't have transportation, the stupid reasons they call 911. Believe me, there are stupid reasons. And one of my partners, when we were still friends, she would like sit behind the patient and go and the idea was to not like laugh at the person's face. I was pretty good. I kept a pretty straight face.
I have to do that.
Because
Sir,
because honestly, even if they even if they were crybabies, which many of them were, they did deserve some amount of respect.
Remind you that you are nonetheless required to follow the rules of procedure, just as any attorney would have to if they were representing you. You've chosen to represent yourself. The state has graciously agreed to assist. They've served the subpoenas on your behalf. They didn't have to do that, but they did. They've agreed to.
Look at his dumb face. I hope I got that one.
Contact the witnesses throughout so that a better idea can be provided to those witnesses as to when they need to testify. They're simply asking for some basic courtesy so they can then relay that information to the witnesses you want to call in this trial.
Does not understand that.
I'm informed of that, Your Honor, but
all right, then let's move on.
That's actually under the confrontation clause in the Sixth Amendment. I should be able to have the right to have witnesses subpoenaed. It shouldn't.
And you have had that.
Why is that?
Again, we're getting a little far afield here, sir.
Okay, Darrell, you've had the right to have them subpoenaed. Okay. You've even had one witness marched through there and terrorized by you. But what you don't have is the right to demand their beck and call to you. They're not your beck and call girls and boys upon your demand, just because, and to inconvenience them because you've decided to stomp through WAUKESHA like the ogre troll dumpster goblin, setting fires and spewing pew wherever you go. I'm sure that's what she wanted to say. I'm pretty sure that's what she wanted to say.
Subpoenas were provided to you. The record is very clear on that. We assisted you with that. I even reviewed them for completeness, and then the state assisted you with serving them. That is something they are not required to do, but they agreed to do in this case. So nothing about your Sixth Amendment has been violated in that regard.
Did I say violated, or did I say I'm not?
So that's you need to understand that, sir.
I don't understand anything. And for the record,
right.
I didn't bring up the word violated.
Let us continue then. We're going to move on, Mr. Brooks. Let us continue with the questioning.
So we're going to move on to subject matter jurisdiction that has yet to be proven?
Detective Carpenter, you can please come on back up to the witness stand, and Madam Clerk, you can have the jurors brought out.
So we're not going to address that at all? That's not going to be proven for the record? Is that a judicial determination that you don't have to answer the question, Your Honor? Is there also a tactic agreement?
Tactic? This time tactic?
All right, you want to do that in front of the jury or just with me?
I wasn't sure if the defendant would have any objections that would need to be heard off the record or outside the presence of the jury.
Well, can you have them hold for a second? Do you have any objection to Exhibit 82?
Yeah, I got an objection.
What's the objection, sir?
What is the relevancy of Exhibit 82?
82 is your interview with Detective Carpenter and Detective Stern. Your objection is to relevance? Your objection's noted, it's overruled, and I will receive Exhibit 82.
Let the jury know that when they come in.
Are
Yes.
you overruling the fact that the true nature and cause has not been presented to me, that I don't know what the true nature and cause of the charges are?
You must have been totally engrossed. Yeah,
You can have them brought out now. All right, thank you.
truly.
All rise.
Your Honor, may I see a sworn
Oh, my
affidavit
God.
of the nature and authority of the court? Or is that a judicial determination? You won't answer that as well.
Let me promise you, as somebody who's only been on one jury and a grand jury, but you know that they're not supposed to be doing this horse hockey in front of everybody. When the jury's walking in, it's supposed to be just the jury walking in.
Welcome back, ladies and gentlemen of the jury.
I hope the record reflects that.
So they know all of this needed to be done before. They know. Somebody said the jury had to have been ticked off.
All right, thank you, everyone. Please be seated.
I'm sure.
Record will reflect that Detective Carpenter is back on the witness stand following the break for the lunch hour. And Mr. Brooks, you may start your cross-examination.
I don't consent to being called that name, Your Honor.
Your objection's noted. It's overruled. Please ask your
Can't be
questions.
overruled.
Yes, it can. It's overruled.
Detective Carpenter.
Now I have you just where I want you. It's time to be questioned by the Goblin. Goblin, Goblin, and Goblin.
Did you attend the parade that evening, November 21st of 2021?
He already said he did.
Yes,
In what capacity?
as a member of the Honor Guard.
And what time did you arrive?
I don't recall the exact time.
What time did you leave?
I don't recall the exact time.
And when you left, where did you go?
Our temporary police department.
Temporary. Explain what do you mean by temporary?
So at the time of the incident, the building we are in currently, which was our main building, was under construction. So we were displaced.
What do you mean by at the time of the incident?
At the time of the parade.
And so the regular station was, what did you say, under some type of construction or something?
Correct.
And so what were you guys using for the temporary police station?
The city annex and city hall. We're in two different buildings.
Does any of those buildings consist of a room for interrogation?
There is at the annex.
And so when you initially interrogated the suspect, why was the annexed interrogation room not used?
Well, when I interrogated you, Mr. Brooks, the annex room was not used because the situation was very fluid. There was a lot of information being learned. We knew this was going to be drawn out. There is no municipal lockup facility at the annex, so it could not be utilized.
And so the police holding room in the hospital was more sufficient?
You asked to go up there for medical clearance.
First of all, I love how he's. Oh, when I interrogated you, Mr. Brooks, using the all, offensive word you and his name all at the same time. Bravo. Bravo. I don't know. I mean, you guys tell me. Is questioning the procedures that the police use at all a valid defense, or could it be a valid defense? I mean, I suppose if they did something against the procedure or against his rights, some of that evidence would be excluded, but that all would have been addressed long before this point, right? So otherwise, I mean, anything that they do, they're doing by whatever procedures they use. They must know that the procedures are going to include having the split up temporary, placements.
So the police holding room in the hospital was more sufficient than your temporary station, which would have been more suitable.
In whose eyes? He just said, number one, you wanted to be medically cleared because of your fake shoulder injury, which was a huge lie to begin with. Number two, he said that there's no holding cell where there's an interrogation room, which means there's extra transporting. I'm just making this up, but that's what I'm seeing. I see myself transporting you. I used to hate police calls, honestly. Most of them.
Yes, it was more sufficient.
And why would a hospital
Hospital.
police room be more sufficient than the actual police station that you were utilizing at the time?
Look at his stupid head.
As I stated in my previous testimony, there was no secure lockup facility at the station.
He's gonna say
In
this
addition to
20
that,
times, I bet.
you requested medical clearance at the hospital.
So was there sufficient lockup at the police room in the hospital?
Yes.
We had areas in the hospital, so when you were being treated by the doctor, you could be handcuffed to a bed. There is no place in the interrogation rooms you referred to at the annex to handcuff you to anything, and the doors did not lock sufficiently.
And to the best of your knowledge, would a detainee have that information that you just stated?
No?
So how come the suspect couldn't be handcuffed at the annex for the interrogation without having to be handcuffed to
Look at that dumb look.
a specific bench or whatever you refer to it as?
Well,
I guess essentially what I'm asking is, could the suspect still be properly detained while being interrogated at the annex versus police holding room in the hospital?
so let me make sure I have this straight. Your question is about detainment. Do I have that right?
I think the question was very clear, Detective.
I think it was very clear.
I can't answer it if I'm not going to get clarification.
And where was the suspect taken upon being detained?
You were taken, Mr. Brooks, upon the time you were arrested, down to the substation on Les Paul Parkway in WAUKESHA.
And do you recall if the suspect was put into a holding room?
Yes.
And do you recall if that holding room had something that would secure a detainee?
Yes.
So why couldn't the interrogation happen there if the suspect could be secured at that location?
You dope. Look at his stupid face.
Well, there are various reasons, and one of the most important reasons is when we took you to the hospital, Mr. Brooks, for your medical clearance, there were now a total of 4 officers there, myself, Detective Stern, and eventually the 2 federal agents. The situation was still very fluid. When I began the initial the initial questioning, it was 11:04 p.m. and there were still a lot of unknowns. So the determination was made to start questioning you, see what information you might be willing to provide us, because with 4 of us, we were confident we would be able to keep you where you belonged, where we needed you to be, as opposed to risking another unnecessary transport. Because, and it's not just personal against you, any transport of any prisoner, there's a risk. So there's no point in taking that risk of that transport when we had the ability to do the interview there, especially when there was such limited information that we had.
So FBI agents were present at the substation that you referred to?
They arrived there at one point, yes.
Was that known to the defendant?
I don't recall.
Is it fair to say that the detainee could have been Is it fair to say that you could have made sure the suspect was contained while at the substation, seeing as how that there was multiple officers present?
Objection. I think this has been asked and answered.
I think he's referring to the substation versus the hospital, so I'll allow it. Overruled.
You were contained initially at the substation, Mr. Brooks, but you requested medical transport, so you were transported. So what I'm explaining to you in my prior testimony is I didn't know at that point if you'd end up going straight to the county jail or what have you. Every transport, as I stated in my earlier testimony, there is a risk. There is a danger. It's not just personal to you, it's any prisoner. So the decision was made to start the interview there based on not knowing where you'd end up for sure, not having all the information, that we weren't going to take the risk of an extra, potentially unnecessary transport back to that facility. You couldn't be held there. You couldn't be held at the sub. There's no beds.
You referred to interrogation starting at a specific place. I'm referring to the substation. Is it fair to say that there was no interrogation that took place at the substation?
Yes.
Yes, that's fair to say?
There was no interrogation at the substation in Waukesha.
Do you recall what information was obtained at the substation?
Yes.
Do you recall what that was?
Yes.
Can you state for the jury and for the record what information you obtained at the substation?
Yes, sir. Basic biographical information. So I obtained your first name, Darrell Brooks, your last name being Brooks, your full middle name, I should say, being Edward. I learned that you were a junior, the date of birth, February 21st, 1982.
So in other words, he confirmed your identity. You know, the one you keep saying is not you. And by the way, on your ID, I believe that's in all caps.
Additional information obtained was your home address, which was you provided as 4014 North 19th Street in the city of Milwaukee. Phone number, your emergency contact, which you provided as Dawn Woods. Whether you were employed, going to school. I remember talking with you about your tattoos and other physical marks that might be on your body. Your hair color, eye color, photographs were taken, things of that nature.
Kept mentioning that name, pretty slick.
Pretty slick.
Sure, disregard that last statement, sir. Please ask questions. You'll have an opportunity to testify later.
Oh, I got a lot of questions.
Great.
And at that point in the investigation, what did you initially know?
At that point, we knew that the red Ford Escape had driven through the parade route and that you'd been identified as a suspect.
And why was that information not provided at that time to the detainee?
The information at the time wasn't presented to you, Mr. Brooks, because, as I stated in my earlier testimony, it was still very fluid. It was very chaotic out at the scene. There was still a lot more that needed to be learned.
So is that standard procedure to not tell a person why they're being detained?
Well, we didn't not tell you. That's incorrect, and it's misleading to the court. You were informed you were being detained for prowling, loitering, disorderly conduct of that nature.
Is that the same as...
Can I finish, please? I just didn't bring up the parade part of it.
Why not?
As I stated in earlier testimony, it was very fluid and chaotic, and a lot of information wasn't yet known, so I was waiting to receive more information.
Did you state in your early testimony if that was standard procedure or not?
It's standard.
So with every detainee that you've ever detained during your career, 18 years, right?
Yes.
It's standard procedure to not tell someone being detained what they're detained for.
As I had stated in my earlier testimony, Mr. Brooks, I explained to you were detained for prowling and loitering and disorderly conduct. Based on the lack of information on the parade, that was not brought up. So what I can clarify for the court at this point is that in situations where so limited information exists early on, it is standard not to convey that information to suspects.
And what do you mean by it's standard?
I mean that I don't tell them because I don't have all the facts yet, and I'm not looking to necessarily accuse them before I know the nature of what they did or didn't do exactly pertaining to that incident.
So it'd be fair to say that it was not a fact as far as the information you learned to that point in the investigation.
Objection there.
Grounds.
Sustained is to the form of the question.
So at that point in the investigation, it wasn't a fact.
Objection, same question.
Grounds.
Sustained is to the form of the question.
At that point in the investigation, the information you had at that time, you weren't sure about.
I guess which part?
All the information that you had up until that point.
Okay, about the prowling or parade, I don't understand which part of it you're talking about.
All the information that you've obtained at that point in the investigation, you weren't sure about. As you just said, you don't try to assume guilt or anything like that until you have all the facts. So at that time, at that point in the investigation, is it fair to say that the information that you had obtained so far, you were not sure about?
I wasn't sure if you were the driver initially, but it was believed you were involved.
And you knew that to be fact?
Yes, the information being provided was that you were involved.
So it'd be fair to say you knew that as a fact?
Yes.
Well, hold on. I'm going to not allow him to answer that. This jury will determine the facts of this case. If you want to ask him his opinion, you do that at your discretion.
He said fact. He said facts.
You asked the question, sir. So
He brought it up first.
I'm going to strike the question from the record, and Mr. Brooks, you're directed to rephrase.
I will rephrase, but I do not consent to being called that name for the record.
Shut up.
Voted and overruled.
You stated that there were some loitering and prowling allegations. Why? To your knowledge, were those ever charged?
Objection relevance.
Grounds.
Overruled. The witness may answer.
No.
And do you recall why not?
No.
You wouldn't even know why not.
So why did you constantly tell the detainee that they were being detained for loitering and prowling if you in fact knew that there was another reason why they were being detained?
Objection asked and
Grounds.
answered.
Sustained. That's the form of the question and assumes facts not in evidence.
What was the significance of the FBI being present?
The significance of the FBI presence was the early on concern that this was a terrorist style event.
And you said that this was a terrorist element. And what is the this? Can you explain what the this is?
When you drove your vehicle through the parade and struck people.
Which at the time you stated you did not know is fact, correct?
That was still being investigated, yes, but I know that's what occurred now.
Now versus then.
Initially, it was unknown if you drove.
That's what I was
stated.
That was the question.
But the investigation showed that you were the driver of the vehicle.
And initially you didn't provide that information, correct?
Correct.
So
Okay, so the dead horse he's beating here, which believe me, I know because I repeat myself, but the dead horse he's beating is if you were arrested, you should know why you're being arrested. And what Detective Carpenter is saying is we arrested and detained you for the loitering and then for the abuse and DV charges while the investigation for the rest of it was happening. As soon as he's got those pictures and shows him in the second day interrogation in that room, that he's got pictures of him driving through the band and the band video that he shows Darrell during that interrogation that we saw yesterday, that, you know, the facts are falling into place for him. Now, during the investigation, according to the judge, this is just the case that's going to be presented, and the jury decides what's true and what's not true, and what's credible and what's not credible. So he is, I guess, trying to discredit the investigation. I mean, you're not casting any doubt, Darrell.
do you know if the FBI continued their part of the investigation?
No. Once they realized it was just
Eventually, the investigation was strictly run by our department.
stomping through.
And do you recall why that decision was made?
My understanding is there wasn't a terrorism link.
Ha. That it was just you stomping.
I'm sure throughout your career you've done lots of interrogations. Are there usually multiple officers that do the interrogation, or usually just one?
It can depend on the circumstance. It's not always more than one, but it can be.
And what would you estimate would be the normal procedure for interrogation as far as law enforcement wise?
I really can't speak to that. I think every department probably has their own potential way of doing things.
Up until that point in your career, when you interrogated the detainee, had you ever conducted an interrogation with FBI present?
Not prior to that date, no.
Made reference to car key being found. Do you recall that?
Yes, I do.
Did you yourself find the car key?
No, I did not.
Were you told by other law enforcement?
I guess told what exactly?
That a car key was found.
I was not specifically. Your items that were located on you during the search were turned over to Detective Stern, and the car key was one of those items.
Ha.
And to the best of your knowledge, you didn't have that information at the time, correct?
At which time?
At the time that the detainee was detained in the substation.
Thank you for that clarification. Go ahead and answer.
I just want to make sure I guess that I understand. So you're asking me what I knew about the key, or if I knew where it was found at the substation? I don't understand. Can you clarify that, sir?
I guess the clarity that you may be looking for is what was found and brought into the substation?
Okay. The Ford ignition key and other items that I alluded to in my earlier testimony include your photo ID and credit cards with your name, or debit card, credit and or debit cards with your name on them.
That you did not search and find yourself, right?
That's correct.
Did you conduct any searches?
I don't recall if I did or not of your person.
So it'd be fair to say you don't know where certain items were found at the time that you learned of there being items found, correct?
No.
No, as in?
No, I knew those items were found on you in the search. Maybe not the specific pocket, but I knew the officers found those items in your possession.
Were you at the scene of the search?
No.
So how do you know where they were found?
Because they were turned over to Detective Stern as your property.
How do you know where they were found, though, if you weren't at the scene?
Because I was aware officers searched you, and it's not reasonable to believe they were randomly in the grass at the house you were at in a city that you've indicated you're not familiar with.
Can we strike that last answer from the record? I didn't refer to any house, grass.
You asked an open-ended question. His answer will stand. Your request is denied.
So he didn't.
So it'd be fair to say that in the question I did not mention a house, grass, or a city? That'd be fair to say?
You didn't mention it, but I know you were found at a house in the city of Waukesha. And I know you're not familiar with Waukesha because that's what you told me when I interviewed you.
Can you strike that last answer?
Request is denied.
On what grounds, Your Honor?
You asked the question, he answered it. If you want to limit, ask leading questions and direct him. That is your right.
You made reference to the house where the detainee was found, the grass, the city. Could it be possible that that's where they were found? The items that you are referring to?
No.
Even though it would be fair to say that you were not present.
Correct.
You made a lot of reference to the body pain and having to be checked at the hospital and being medically cleared. Would that be fair to say?
Yes, we took you to the hospital for clearance.
Are you yourself a doctor or have any training in the medical field?
No, sir.
So it'd be fair to say that you cannot know how a person's body is feeling. That'd be fair to say?
I can't explain exactly what another's body's feeling, correct.
So it'd also be fair to say that there's a possibility that you can be incorrect about assumptions made to pain reference. That'd be fair to say?
I think that depends on the circumstance. In this specific circumstance, you told me.
The last follow-up if he wants it.
Okay.
Next questions.
You made a reference on one of the exhibits. I'm not sure exactly which one it was. It was the first interrogation in the police holding room in the hospital. In that exhibit, you made reference to the FBI being present because you were short-staffed. Do you recall that?
I don't recall exactly what I said, but I recall acknowledging their presence, yes.
And you made a reference to short staff. Can you explain what does short staff mean?
I don't recall if I said that or not.
I don't know if it's exhibit 172 I'm referring to. Can you pull up exhibit 172, please?
We refer to the photo of the identifiers and the items found.
Is that
It's
172?
172, yes.
Well, I don't think, is it 81 then I'm referring to?
81 is the audio recording.
Okay, it's
I'm
81.
sorry, 81 is the video and audio.
Of the,
Was it just the audio? I was right the first time. It's
okay, I think it's 81.
You would like the audio recording from the hospital.
Yes, Your Honor.
Is there a
You are
part
so
you'd like
not
to direct the
included
state
in this
to
club,
when we
Darrell.
pull it up?
Because it's the audio, I'm assuming it'd be probably as soon as the defendant is brought into the room.
It was played starting at 4 minutes and 25 seconds through 14 minutes and 25 seconds. Do you want it started right at 4:25?
Yes, Your Honor.
Okay. The state would please assist with that.
How long would you like it to be played?
Do you know how long you want it played, or do you want the whole thing? The
I don't-
same clip?
I don't need the whole thing played.
This was exactly
From
she
what
was
I
talking
recall,
about.
the point that I would refer to is pretty early in that.
All right.
Well, how about we...
This is exactly what Leslie Basie was talking about, where she said he needs to be careful saying about this or pause here and all of these generalized references to these audio and videotapes, because he prattles on and on and on because Darrell can't keep his mouth shut about all kinds of things. But what he wants to do is play the part where Detective Carpenter says, we have the FBI here just because we're short-staffed. Which he, I believe, indeed says. Which they were indeed short-staffed because, Darrell, you stomped your way through an innocent Christmas parade like a freaking troll, barreling through, spewing poo all over the beautiful town of WAUKESHA and these people. But go ahead.
Start at 4:25, and then you say pause, please, when you want it to be paused by the state.
Okay.
All right, go ahead.
Doofus. Pause it here for a moment. So if you will. Okay.
Right here, Darrell. I'll go grab you. I'll tell you.
Darrell?
Yes, sir.
Hey, Darrell. I'm Jeremy Wojciechowski. I'm the FBI. FBI? Yeah. That's my partner.
FBI?
Yeah.
I'm Mary. Yep.
They're just kind of helping out because we're so short-staffed tonight. So,
Thank you.
It's paused at 4 minutes and 56 seconds. Go ahead.
From hearing the audio on this exhibit 81, do you recall saying that the FBI was present because you were short-staffed?
that is my voice. I don't recall saying it in the moment, but that's my voice.
That is your voice.
That is me talking.
So from your recollection, do you recall being short-staffed at that time?
Yeah, why do you think?
Yes.
And can you explain what the short-staffed mean as far as...
Because some doofus ran through a parade.
At that time, what would short-staffed mean?
That we were just very short on resources with what happened
With what you did.
down at the parade route and the mass casualties and the amount of officers it took to secure that location. We were very short on people.
And
People were called in off duty.
You made reference to the short staff being the reason why the FBI was present.
Yes.
Is FBI usually present in the situation of short staffing?
No.
Nope. You bring that one home, Darrell?
We put that off, or do
Yes,
you need it?
I'm sorry.
No, it's okay. I just want to make sure if you needed it, it's up. All right, it's
Sometimes
taken
I
down.
forget it's still up there.
Makes two of us.
Yeah. And you made reference to recording the interrogation on your phone, correct?
Yes.
And why would you use your phone to record an interrogation? Especially one of this magnitude.
This magnitude. Like, What
Because
it
the
was so
camera in the
important.
room didn't have audio capability.
And were you informed of that? Or let me back up. When were you informed that the camera that was in the room did not have audio?
I don't recall exactly. Prior to the interrogation.
And who were you told by?
Hospital security.
Was that the first time you had ever used that police holding room in that hospital?
No.
So it would be fair to assume that you were aware that that room had cameras.
Of course.
Yes, I knew it had cameras.
And have you ever conducted an interrogation in that room before that evening?
Interrogation, no, but I'd use the room for other purposes.
So what prompted an interrogation in that room that specific evening?
Well, as I explained in my earlier testimony, the situation down in the downtown area of WAUKESHA where the mass casualty incident had occurred was very fluid. It was still unfolding at that time. We were learning more and more and more about what occurred. We decided to start the interview at that location to see if you'd be willing to shed light on for us as to what you did or did not know. And again, I'll go back to statements I made earlier. There's a risk inherent with every transport. I didn't know where your ultimate final location was going to be that night, so to now start bouncing you from facility to facility to facility unnecessarily was just something we made the decision not to do.
And at some point, the detainee was moved to the Muskego Police Department, correct?
Yes, you were moved to the Muskego Police Department later in the evening.
And when did you learn that that would be a location that the detainee would be going to?
We made the decision to try to use that location after the first interrogation attempt.
Oh, I'm sorry that I didn't hear the last part.
I'm sorry, after the first interrogation attempt.
First interrogation attempt. How would you define attempt?
We asked you, you said no.
Well, when we were at WAUKESHA Memorial Hospital that night in the police holding room that we've discussed, I read you your Miranda rights verbatim from the WAUKESHA Police Department Miranda statement form. And at that time, you indicated you didn't wish to speak with me.
So it would be fair to say that the Fifth Amendment right was exercised at that point.
Right to silence.
Under the Fifth Amendment.
Yeah.
So acknowledging now the fact that the Fifth Amendment right was invoked not to speak, or as you say, the right to silence, why did you continue to record on your phone?
So we are trained at our police department when you do an interrogation, the recording is to be left on pretty much until you try to effect transport. So typically what we would do is if our building hadn't been under construction and when we'd been able to get you back to our police department, where in that situation we may very well have transported you, just because we would have had a municipal lockup there and we could have held you for the night. But that again was difficult based on the fact that we didn't have that possibility at the time. So if someone's in an interview room and at our police department, we'll leave that, even after the interrogation's over, we'll leave that video running until we come back and remove the individual from that room.
In other words,
Even once a detainee has invoked their right to silence, you still continue to record? Is that a standard practice of your...
yeah, Darrell, that means you shut up. It doesn't mean we all poke hot sticks in our ears.
Agency.
Stupid.
Yes, it is, for as long as they remain in the room.
And so when did you start recording?
Are you?
It also could prove if they did something wrong by, say, continuing to ask questions, other than, are you going to change your mind about invoking your rights? But if they continue to ask questions after the right's been exercised, then that tape could go against them. So,
Talking at Waukesha Memorial Hospital?
dum dum.
Correct.
Prior to you entering the room.
So you started recording before the detainee entered the room, and you said you keep the recording on until they leave the room.
Yep.
So would it be fair to say that there should only be recording while the detainee is in the room?
No.
And you did say for the record that that's standard procedure in your agency.
In regards to the interview rooms at our normal police department, which wasn't
which you tried
available
to
at that
mimic.
time. Yes.
Would it be fair to say that you were not at the normal police department?
Yes, however, with the audio, I was still trying to make sure I followed the policy to the best of my ability.
Can you show proof of that policy?
I don't have it.
So it'd be fair to say that
Since I'm a
there's
liar,
no way to determine if that truly is policy if it can't be proven.
Objection, argument.
Grounds.
Sustained. As to the form of the question, it's argumentative.
How can that policy be proven?
Objection.
Grounds.
you can subpoena
Sustained. On
the
relevance
SOPs
grounds.
or the MOPs or whatever P's, policies, books that they have.
Do you know where that procedure is located in your agency rules?
Nobody does.
Objection,
Grounds.
relevance.
Sustained.
Grounds for the sustain, Your Honor?
Relevance grounds. Relevance. Not relevant. Next question.
Look at his dumb
This is
eyes.
not relevant?
Yes, it's not relevant, stupid.
No. Keep going.
Oh my god.
We can take it up later outside the presence of the jury at our afternoon break, but for now, keep going.
I follow, Your Honor. I apologize.
Uh-huh.
Keep going. Okay.
So once the detainee was taken to the Muskego Police Department,
Bad pistachio.
that would be a pretty standard police department. Would that be fair to say?
Yes.
And a second interrogation also took place at that police department, correct?
Yes.
Any reason why the first interrogation couldn't take place at the same police department that the second one took place at?
Weren't there.
Well, the first interrogation, again, wasn't at a police department. You know, Muskego was utilized as they had a lockup facility. So we interviewed you there.
Around what time was the detainee taken to the Muskego Police Department?
I don't recall the exact time.
And you also stated that another law enforcement officer.
I apologize for the interruption, but I just want to make sure my jury is in good shape. If you want to just take a moment to stand. It's a little slow, I think, for them, so we're just going to stand for a minute. Again, my apologies for the
Because
interruption.
you're asking boring questions. Only one relevant question. Why did I do it?
Anyone on my jury need a break? Are we good? I'd like to keep going. Anyone? Okay. No response to that. They said they're good. All right, we'll sit back down. And again, my apologies, Mr. Brooks. Hopefully you know where you were.
Yeah.
I'm included.
It was another law enforcement officer who actually did the transport of the detainee at that time, correct?
Yes.
And you stated earlier in testimony that you and your partner followed behind that transport. Is that fair to say?
Yes.
And I'm assuming at some point that you will actually strike that. You stated to being present during the booking process into the Muskego Police Department. Is that fair to say?
Yes.
So why couldn't interrogation be conducted at that time, which would have been more ideal, considering that you said there was a lockup. I forgot how you referred to
Thought
it,
you had a
but
conscience.
basically like a room that the detainee could be secured.
Maybe they thought you had a conscience, Darrell. Maybe they thought seeing all those people that you injured and terrorized, which is why the FBI was there, maybe they thought you'd say something at the hospital.
Well, you had been talking about at that point when we arrived at the facility with you that you hadn't eaten all day, you hadn't slept, so we wanted to give you an opportunity to eat, sleep, clear your mind, and
about what
refresh
you're
yourself.
In other words, some humanity.
And what bearing would that have on interrogation?
Well, I mean, you said you hadn't eaten, you hadn't slept. So I think a person is more focused when they're fed and they're rested. So we wanted to give you the opportunity to do that.
In your opinion, how would that have affected interrogation?
I'm going to excuse the jury right now. So if our jury, we could stand for the jury so I can take up a legal issue, please. All rise.
Into something I don't understand. I hate it when you can't open the pistachio.
All right, thank you. Be seated. So I'm going to take up two issues right now. One is when I paused earlier and told Mr. Brooks I would allow him to, it was regarding the policies. I want to know, as the proponent of the evidence, why you think that's relevant. And then secondly, the questions I believe that you are asking related to the interrogation, unless you can convince me otherwise, go to a legal issue that this court has already determined, but I'll hear you out on that. I didn't want to make an assumption, but I also didn't want to have you question this witness about what really are legal issues that this court previously addressed regarding the admissibility of the interviews.
Well, to the first one, about the policies, that's relevant because I think it should be stated for the record why he left his phone recording after he acknowledged that the Fifth Amendment right to silence had been invoked. At that point,
shut up, stupid.
interrogation is supposed to stop.
No, it
completely.
did.
Well, I understand what you're saying from a legal perspective, but that doesn't mean the recording had to stop in and of itself at that point. He did provide an explanation on the record.
His explanation was that it's policy, right?
He answered the question, why do you believe having the specific policy and him testify about the specific policy is relevant to his testimony?
Well, I believe that if that's in fact policy, it should be proven. It should be proven that that's a fact, that is a real policy. For all we know, he could just be saying that it's a policy. And at that point, it makes him continuing to record after the Fifth Amendment had been invoked.
Well, right now, you assume facts that are not in evidence, sir. And so you're the proponent of this testimony through your cross-examination. And so without something more, sir, I don't see where there's relevance as to what the specific policy is.
Can you see what I'm getting at, though, Your Honor?
No.
If he's saying that this is a policy of his agency, he should be able to prove that that's policy. Because at that point, if there's no way to know that that is the correct procedure that they use every time, then why?
Again, making a lot of generalizations that I don't think are accurate as to what he said. This is a trial, sir, where the allegations in this case are that you drove through the Christmas parade, right, and caused death and injury to a number of individuals. There's also those other charges related to the bail jumping, the battery, and frankly, his conduct isn't on trial. We're not here about a police misconduct trial. I'm not saying that some of this information might not be relevant to his credibility, things of that nature, but you have to, again, you're the proponent of this. Why do you believe those policies relate to an issue of fact in this case or otherwise go to your defense?
I believe that is relevant because it can show that at the very minimum that first interrogation and anything related to it should not be admissible as evidence.
That's a legal determination that I've already raised. Your attorneys represented you at that time. They made a variety of arguments. So to then make this trial about that interrogation, it's not relevant.
I'm not making a whole trial of it.
But the issues are legal issues that this jury will not be asked to answer. I've already ruled on the admissibility. That's a legal determination. So I'm not seeing the relevance to those specific policies, and there is simply no requirement that the state or this witness has to prove those policies. You are representing yourself. Hold on, let me finish. You're representing yourself. I'm not aware of any subpoena that required him to bring those policies with. So that would have been on you if you felt it important to cross-examine him on those policies to require that. I'm not aware of that. Have you done that?
Obviously, it was going to come up.
Did you issue a subpoena ducis tecum to this witness to bring with any of his policies related to interrogation?
How can I do that myself, Your Honor? How can I do that from a jail cell?
You were given all of those blank subpoena copies, sir, and you could have filled that out in a way for this witness to require. You didn't do that. So
who would have served him?
The state would have. They served your other subpoenas. But be that as it may, that's not what we have here. So I believe that your line of questioning is on a topic that's not relevant to the issues in this case. So I'll give you one more opportunity. Why do you believe that questioning him about the policies are relevant to your case?
It's relevant to the case because why would he be recording before people are even in the room and then after?
Well, that's argumentative, sir, so that's not a legal basis.
Once the Fifth Amendment is invoked, interrogation is supposed to stop, period. There's supposed to be no more recording, no more questions asked. That should be the end of the whole interrogation.
These are legal issues that you're trying to raise before the jury. I've already dealt with the admissibility, so you've not provided a legal basis to further question this officer about policies related to the interrogation and the recording. He has answered questions. I gave you some leeway on that, and his answers are before the jury. Certainly you'll be able to argue the meaning of that or the lack thereof during your closing arguments if we get to that point. Let's move on, though, to this issue about why I excused the jury. And again, I believe you're questioning him about legal issues that aren't relevant, but you're the proponent, you want to question him, what's the legal basis you believe I should allow you to continue with that?
What legal basis are you referring to?
I believe you were attempting to elicit information or evidence, testimony from this witness on issues that are not relevant.
Is that referring to the same question?
Not
I
the
asked about
policies, what I
policies?
just stopped the testimony for, because I don't want to create issues in front of this jury related to legal issues that are not before them to determine.
And is that referring to the question about the policies?
No. You were asking him, why did you stop? Why did you not question him further? Meaning, why did this detective not question you when you got to the Muskego Police Department? Why did they wait till the next day? I stopped because I know the law on this area, and I know that when a subject invokes their Fifth Amendment, or when you're a defendant in state, it's the 14th Amendment, but nonetheless, right, and you have rights under the Wisconsin Constitution as well, but that because you only invoked your right to remain silent, they waited to question you until a sufficient amount of time had passed, in addition to the other reasons. I'm not going to let you question him in front of the jury about that specific thing. Or at least I'm cautioning you that I'm stopping it because I don't see where that's relevant, but if you keep pressing him on that, you're going to open up the door to him saying, because I was following the constitutional requirements and giving you a break in the questioning so that I could, get a statement I believe would be admissible later on. That's what I'm trying to avoid.
With all respect, Your Honor, I don't think he would have said that.
My concern was we were headed down that path. So if there's some other reason you want to question him.
The 14th Amendment would have been referring to the having the attorney present.
I'm sorry, say that again?
So you said, when you stated that you know the law in that area about the Fifth Amendment and the 14th Amendment, what were you referring to on the 14th Amendment?
I'm not going to explain that any further, sir. Let me just ask the state if they see this.
Attorney Bailey, that's exactly what I was getting at. Attorney Bailey, that's exactly what I was getting at.
All right, well, you understand it's my job to protect the record, too. So I want to make sure that, all right, so with that understanding that you are questioning this witness about why they didn't take you to Muskego for the first interview, is that where you're wanting to go with all of this?
That was the question.
All right, well, I might have misunderstood, but in any event, it gave us an opportunity to talk about the other thing, so that's okay.
So is that a fair question to ask then? Because I'm confused now if I'm even allowed to ask that question.
I think part of the issue sometimes, sir, is sometimes the questions aren't as artfully worded as they could be. I know you're doing your best. I like to look at it this way. Questions that are a sentence at a time, meaning a thought at a time, because then they're not compound, are the easiest for a witness to answer. And when you start bringing in other things, it can be confusing, and then I might not understand, or a party or a witness might not understand what you're asking. So looks like it's one of those situations where I was a bit unclear. It's been clarified. If that's the line of questioning that you are going to go, then that's fine. Then I would allow that. I'm not going to stand in the way of that. If the state objects, obviously that's a different story, and then I'll have to rule on it. But I think we're all on the same page now.
And just for the record, Jared, I will be objecting. I don't want there to be, just because I think this has been asked and answered. He was taken to WAUKESHA Memorial Hospital for medical clearance. They want to minimize the number of times that he's transported, and they needed the information sooner rather than later. So I will be objecting as to asked and answered. I just didn't want to, we asked the question that the court suggests, and then I object, and so I do want to put that on the record just so the court's prepared for it.
Understood.
The question of why wasn't the first interview conducted at Muskego Police Department had not been answered.
I'm going to let you ask that question. So even if they object, we'll put everyone on notice. So because I think it's reworded a bit differently, so I think it's fair. I'm going to let you ask that. All right? Let's bring the jury back out. It's time. I might have to get me a little water too.
Actually gonna cut this one off here and let this, we're gonna do this in 2 parts because I need a break. I actually took a little break. I took the dog to the vet. They said she's fat. I think like most of us. But then I took her out for a bike ride. I am getting my camera ready to go on my motorcycle ride. I might post that too. Definitely go either today or tomorrow. Might go today. I don't know. Depends. And everybody have a good day. We'll get the rest of this one. Cross-examination. This is a tough one, man. This is tough. He's mad. Like, subscribe, comment. See you later.